Okay, evidence, surprisingly, you taught me something.
Right.
But torts, how did I get an A in torts?
Really?
I don't know what is going on with torts, but.
See, I kind of feel the same way about common law, actually. It's like, how did I get an A in common law? Because
Right.
I go through the multiple choice, and I just screw them up every time. And I'll read through the answer and go, oh yeah, that makes sense.
Yep.
Never thought to write that answer, but
yep.
Yeah, okay, it makes sense now I look at it.
Yep. There was one, I did the, like the LPT where it's like a mix of the, I'm assuming you did Barbary. I got, the answer was strict liability. I never even thought the word strict liability going through them, so I'm like,
Yeah, we didn't really do strict liability.
I should spend some time looking up torts.
Yeah, that's what I've been doing is anytime I know I'm like goofing up a particular subtopic, I just have a running Word document. I'm like, okay, you start going over this.
Property's hit or miss.
Yeah,
I hated property. I still hate property, but it's hit or miss for me.
Good.
Some topics I'm like, okay, yeah, I got it. And then other ones I'm like, oh, I see where you came up with that, but that didn't.
Oh, it's weird. A lot of the new stuff that I learned from the Barbary lecturer might be better than the stuff I was supposed to have learned from Moneyball.
Oh, yes.
I like it a lot. Because it's so much more straightforward, and I like have to think back to like the terror mixed with the like him just being like, well, now I'm going to switch the facts a little bit and screw you up every time.
Are you Kentucky or Ohio?
Kentucky.
Okay, so then you started contracts by now. The parole evidence rule, the way that the one guy explained it to us, or excuse me, the parole evidence rule, why didn't Alden just say that? It took him like 15 minutes, and I'm like, that's all? Why didn't Alden just say that? And stuff like that is so annoying. I'm like, we went over that for like a month and still didn't get it.
Yep.
And he just disposed of it. Same thing with hearsay.
I feel like I could have gotten at least close to an A in every single class if I just didn't listen to the actual
and just did the
teacher,
Barbary modules
the
the whole time.
modules.
That's how I felt about secure transactions listening. I haven't gotten to it in Barbary yet, but in UCC, listening to folks talk, I'm like, what the hell are you talking about? None of this makes any sense. So before the final, I did like the 2L, 3L thing, and that guy, I'm like, oh, why didn't you just say so? It's so easy.
I thought, for some reason, I thought Kentucky didn't have secure transactions. I was like, Ohio people, yeah, no, they don't. Are you taking Ohio?
No, I'm in Kentucky. I didn't know that I wanted to stay up here until it was too late to apply for the Ohio bar, so I'm just rolling with it. Yeah. It's fine. My favorite is when people are like, you should take Ohio first. Should I?
Yeah, so it's a little late.
I'll keep that in mind, thanks.
Eric was the exact opposite, which is kind of funny. He's like, yeah, I'm going to do Ohio. I'm like, it doesn't make sense for you to do Ohio. He's like, yeah, but like everybody's doing Ohio.
No, everybody knows that he wants to be
he wants to
work for the prosecutor.
Yeah, and he wants to stay right here.
Yep.
He has no business across the river.
Nope.
And he's just like, no, I'm going to do Ohio. And then like 2 weeks before the Kentucky app was due, he's just like, I think I'm just going to do Kentucky.
Yeah.
All right. I told you. All right.
Could have saved you an interview, an application process, another $1,000. But yeah. Poor Lindsay. Lindsay got a job. She was all signed up to take Ohio bar, and she got hired at the place she used to clerk for in Burlington, and they wanted her to take Kentucky. So she had to apply with like a week before the Kentucky application was due. She was all set to go. She was fit, and they're like, nah, can you take Kentucky?
Yeah, I mean, it's not too bad an app that you have to scramble around and do it all in a week.
Yeah. And I can't even imagine, I didn't move at all while I lived here. So, and aside, like I listed my dorms just to make sure I was being safe. But I didn't have that much I've only lived in Kentucky my whole life, and my parents lived in the same house since I was 9. So if you've moved around a ton and lived in a gazillion different states, oh my God. Or had some sort of like criminal history that you had to like address.
bar results for Kentucky?
I have not.
So the lowest it has been in recent history is of all takers, 60% pass.
When was that?
Like 2017.
Okay.
So I don't think being in the like 60% that passes, that doesn't sound that hard.
Did you know that the CPA exam is curved? They only allow like X amount to pass.
Yeah, that's scary.
My best friend's been trying to pass it for like 3 years now. So I'm like, well, at least it's not like curved. It's not, the system's not against us.
Mm-hmm. Exactly. And like the more I break it down and like think about, and the more I talk to Professor Burton about it, it's like you need to get about 65% of the multiple choice right. I got a little doing before I can probably do that. The essays, if you just write what the issue, get close to the rule, have decent analysis and conclusion, that's a passing essay already.
I did an essay yesterday. I completely missed like the issue spot of the third problem, but I did so well on like the first question and like okay on the second one that I was above passing. So I think as long as you do like really well on one of them, even you can pass the essay.
Right. And that's what, Professor Burton was like, you start out with 50 points. They give you points in five-point chunks. So you literally you start out with 50 just by writing pretty much nothing.
75 to pass the essay portion, right?
Right. So then you literally write 5 things that they go, yeah, that's correct, that's correct, that's correct. 5 per essay, and then you're passing. So like, it's not that daunting, it doesn't seem like.
Don't you remember, I keep telling myself that because I'm trying to not like make it so obnoxious in my brain. Whenever we had to go to that mandatory Kentucky bar admissions meeting, and that woman was like, if you have some sort of sentence like this question is testing me on secure transactions, then that's also like more points than you can pick up.
I do not remember that.
I vaguely remember her saying something like that.
Okay.
And if you put something down, that's how you get the 50 points. Because she had said some story. They were testing on tax at the time. Praise Jesus that we don't have that.
Right.
And she was like, I knew going into the bar that I was a lost cause. So all she said was something like the U.S. tax code was written in 1927, and she knew she would get at least half the points like for that question, and then like picked up points on the other essay questions. So if there's one subject like trust, there's a lot NASEP did not teach me about trust. I was very surprised about that one. Also, I hated that guy.
Yep.
Hated that guy. That was very surprising how much trust I did not learn.
Yeah. Well, that's the good thing is just you don't really need to be master of any of it. You just got to at least understand the basics and all of it.
Yep.
It's easier said than done. But.
At least the MBE is only 8 subjects, 7 subjects, whatever, however many. It's not like all of them.
Yeah, I mean, 200 multiple choice is pretty rough, but breaking it into 2 sets of 100, it doesn't feel horrible. I bet at the moment it probably will, but I don't know. I'm probably just doing the most I can to like talk myself into not freaking out.
Yeah, definitely. Definitely. I love everyone in my life. It's like, you'll be fine, you'll be fine, you'll be fine. I'm like, okay.
Well, the numbers show that there's a good chance I won't be fine.
Or like everyone at my church, oh, you don't even need to study.
Oh, yeah.
Well, I'm going to, but thanks.
Thanks for the faith.
I will gladly look on it from the other side in hindsight. I'm not going to risk it. They said bulletin contracts last week wasn't even very helpful.
Really?
That's what I think Joseph told me, Lindsay. I don't know if they said that.
Joseph and I just had a pretty interesting job situation.
Didn't you guys worked?
We worked at Gertz together, yeah.
Yeah.
And then we both interviewed for this job with novel law firm.
one that Kirsten apparently got.
Yeah.
Kirsten Pullman?
Oh, really?
That's what Lindsay told me yesterday.
Interesting.
You guys both interviewed for it?
Mm-hmm. And I never heard anything back from him. And he seemed to really like me, so I was just kind of surprised by that. And then my mom's an attorney, so she ran into that guy at the Louisville KBA thing this week. And she's like, oh, I think you interviewed my son. And he's like, oh, yeah, I did. He was great. I offered him the job, but he turned it down. And I was like,
What?
Yeah, she called me and she's like, did you turn that job down? And I go, no, he never was in contact with me. And she's like, well, he said that if you want it, call him up and then he'll give it to you, that he really wanted you. I was like, what?
That's so awkward.
Yeah, so I don't know what that is supposed to mean.
Who did he talk to? Call him up and see if the job's still available.
Right, I probably ought to, but I was like, okay, that's kind of weird.
That's so awkward.
And I'm just like, I don't even know how would you even call him up and be like, yeah, apparently I got the job here? Like, what do you even say to that?
Apparently I turned it down.
Yeah, apparently I'm rescinding my rejection.
That's so weird. I know Joseph's applied to places like all over the country.
Really?
Yeah. He applied in like North Carolina and Virginia, and he likes immigration law, so he could do that like everywhere. That's so cringeworthy.
Right. It's just,
That's cringeworthy for your mom.
Mm-hmm.
That's cringeworthy for you to have to make that phone call and be like, you didn't call me, I didn't turn down a job.
Yep.
Good luck with that one.
Dang it. Do you have a job?
No, not yet. I've applied, but nothing yet.
Yeah, I feel like nothing I've applied for yet. I'm like, yeah, I really, really want this.
Yeah.
All of it has felt like,
Give me something to do until something better.
Exactly. So I just kind of feel like something will probably fall into place.
I was talking to Lisa Moore about it, I don't know, May, and she said that a lot more jobs open up after the bar is over. There's not as many places willing to hire people who haven't passed the bar yet. So like after we pass the bar, the world is our oyster.
Okay, cool. I had this one, I ended up not even coming to the lecture on Tuesday because I was interviewing with Judge Gentry here in Kenton County. Or it's not here, but yeah. And I call Eric up because I don't know anything about like the local people at all, really. So I call Eric up and I'm like, do you know anything about this lady? And he's like, no, I don't know anything about it, but I know a bunch of people who will. Let me call them.
Yeah.
So he calls me back in like 10 minutes. He's like, yeah, you're going to be really, really glad that you had me call this person. And I go, why? The word disbarred was used pretty much immediately.
I've met her a few times.
Apparently she's under investigation.
I've heard there's some drama going on within that office.
Right. So apparently she's under investigation for it. Apparently she's lied to the investigators about it, and it's apparently coming to a head within the next couple of months, and that she won't even be there anymore.
I met her a few times at like women's lawyer meetings in court. She was appointed.
Yep.
And then she just most recently ran for re-election and won.
Yep.
She's really nice.
Yeah, she seems great.
But she can be a little sassy sometimes.
Yeah, I got that.
Yeah. But yeah, I have heard, in fact, there is quite a story brewing.
Yep. And so, apparently the person that Eric was talking to said that, like, not only is it a rumor, like, it's true, and it's going down. So, probably don't want to get in the middle of that.
No. Hello. Long time no see.
I know. I went up to Lori's again after you left.
Oh yeah, I figured because Derek was talking about going to get alcohol. My cat was going to chit chat.
Yeah, so we did. But I went up there. What time did I go? I probably left at 9. And life is just fucking depressing. And Peter said to Derek, Peter was like, what's something going to do after July when she has no excuse to not hang out with us? And he was like, she'll just tell us that she doesn't want to see us.
She's tired.
Like, it's not an excuse. So I was like, if they think it's an excuse, we can come up here when I'm sitting in my office all day.
I take it you haven't heard anything then, Alex, about that job?
She said that I know in 2 weeks.
Russell,
The whole interview is weird too because she doesn't think that you walk in there and she goes, do you have any questions for me? Which you always have to be prepared. We use those up pretty quickly. And then she just kind of, she has a panel of 2 other people with her and she just goes, so, does anybody else have any questions? Just like, were you prepared for this at all? And like, none of them even read my resume. They just kind of looked at it like, I interned with the Supreme Court in high school, so it was like nothing big, but like I have a real big, like, Kentucky Supreme Court.
Yeah, definitely.
And the one guy just like, oh, so you worked in the Supreme Court? I was just like, yeah. Sure. And he's like, well, then you know, like, all about, like, you know, what it takes to be responsible in such and such types of offices. It's like,
You were like 16 years old.
yeah, exactly. It's like, well, you know, I was pretty young then, but yeah, no, I definitely picked up on it, blah, blah, blah.
Where was this?
My job interview with Judge Gentry, it was just like the weirdest experience. The whole thing was like so odd.
That's because she's weird.
Yeah, I picked up the vibe pretty quick.
Yeah.
She one time in the court, I sat next to her, and what was this? In March, maybe?
I feel like it was in March.
I don't even remember seeing her in court.
I feel like it was in March, and she's sitting like next to me, and she goes, so Courtney, it's March, you got a job lined up? And I'm, oh Lord. Ask me how my day was, what subjects I like, what I want to do.
You ask stressful questions.
It was very aggressive, like, and, yeah. So, anyways.
Yeah, her only substantive questions to me were, what do you like about Chase? What was your favorite subject? And then she like scoffed when I said that it was PR. She's like, why? How you don't get sued? Like, I don't know.
That's kind of cruel.
And then after that, she was just like, oh, like, what do you do for fun? Like, what music do you like? And then her mediator goes, there's like an awkward silence, and he goes, so, what have you heard about this? And I'm like, and I was like,
Wait, is this still Gentry? What did you hear?
I heard a lot of stuff, but I said,
Nothing.
I haven't heard anything. And he goes, you won't get in trouble if you tell me like what you've heard. And I just go, I don't follow local politics. I don't know what you're talking about at all.
I've literally
No.
heard nothing.
For the longest time, for a really long time, like for almost 2 years, I worked for Linda Talley Smith, the Boone County Commonwealth attorney who had all that drama with David Dooley. Had no idea, like literally had never even heard his name whenever I interviewed with her. And she had made some comment, like in passing about something like you see on the news or if you've read about this on the news. And I'm just like, nodding along. Didn't know. Got the job. I started like 3 weeks later. And the day before I started, my friend Meg was like, she had an affair with a detective, and I'm like, that's what she was talking about. Had no idea.
Yeah, so seems like there's a lot of that going around.
Because all her Commonwealth attorney also had affairs with detectives. Well, then why does Linda get so much hate? Because she doesn't deserve it.
This person got hate too.
I think
She also
just
got
because of the
elected out.
circumstances.
Yeah. She also got out of office.
I rep hard for Linda.
Well, I think there's another one of these in a few weeks. I want to hear a follow-up about whether or not you'll be the new staff attorney.
Who all did you meet on our staff?
The assistant, I forget what her name was. She seemed really nice, and half the bar worth it?
I always recommend it for repeat takers. Yeah.
Because I looked at it and then I had like immediate sticker shock and was like,
Yep.
that's a lot.
Yeah.
I was like, I bought a lot of fundamental stuff. I don't know if I quite want to jump into this.
I don't think it's necessary for the first time.
A year ago.
I don't.
A year and a half ago.
And you can purchase tools.
Yeah, logo, whatever.
You know, I mean, you're not gonna have time to use everything if you keep buying something new.
No, I went on and looked at the prices and was like,
Yeah, I did. I had sticker shock too.
Yeah, and I typed in, I was like, oh, well, I have like, $30 off.
Yeah.
I was like, oh, okay.
yeah, I know.
We got that manual book.
Yeah.
It has like actual bar exam questions.
Yeah, and it's like
$48.
something like that.
Yeah.
I asked Holker and McFarland, and they said that they recommend the manual book for the first time.
I feel like everyone has said good things.
And what I bought the book from Jenna, and she said that all of the questions in the manual ended up being on adaptive bar.
I also like the critical path.
They're my favorite.
Yeah, they're good.
I've had them. What I do is after the lecture's over, that's how I review my notes. I'll go through and I'll add like notes to the.
You're so different than I are.
No matter.
Yes, I don't know. So,
I don't know what you want. I love these.
I got mine from Canada. They're 2016.
Yeah.
Yeah. Mine are just like solid, large.
Hello, how's your baby? Do you have pictures?
Yeah, he's a big before I start.
63
A
hours.
good one.
Have you met Annie's baby yet?
At a graduation.
Yeah.
Don't
We
push
have
it.
the bar, we're gonna put that into it, her on the baby, so they can actually
So
figure
good.
out, like, he is supporting out, he's studying and understanding.
Yeah.
We can hang out, be best friends, baby.
Very adult. Yeah, here's, so my sister has I was so tired, I know it. Yeah.
You know when you can and when you can't.
Like 6 weeks before.
Yeah.
They were so
He was born on New Year's Day.
That was my first thought when you said that. I thought, oh my god, I didn't think I could do that.
It's
Driving
just
down there,
outside.
Well, Tommy was yelling at me because I kept trying to find a parking spot. Like, mine's a
You know,
little
if you go out
smaller.
further, we could have already been inside by now.
Yeah.
Further up here. And that's what I was saying. Mommy said,
understand how
tired.
Yeah.
But my husband was a little guy. We, have my dinner unit in today, and my mom texted me last night, and she's like, because I told her, I said, Mom,
I feel like it's usually going to handle it every week. Like everyone's super excited the first
Oh,
week.
yeah.
And
Hey.
last week they're
She has like highlighters and water bottles.
Oh, yeah, we are.
Yeah,
Yeah, so I went to get the coffee,
Oh,
I left my coffee
Like,
in
are
my
you
car,
like,
so I was like,
I just
Oh, I love
like
that
feel
coffee.
like I need to do it just
So
to
this
be
is gonna be
like,
like we're not really ever been review. Like I get all my lists in Covington. I think kind of a little bit. So this morning I was like, coffee cup. Look at that. And then she was like, she's like, well, the biggest size is this unless you get a mug. That's your cup of coffee.
I've been reading some of my dad's office.
So I paid like $10. But I didn't reuse it. Good cup.
I already used all my like free credits here, you know, like how they get money or whatever, I used them all up. She's like, what are you asking? I feel like, I felt like a, you know, I'm sorry, because I wanted to make sure I asked. She's like, why? You're good. You can have that.
I was like, it's always quite confusing.
This time I they're gonna need a bird. Oh, really?
Yeah. I think I tried it twice and it didn't work.
No, you just, well, doesn't matter now, but then they were out of paper, so I opened up the cabinet, and I found like really nice stuff, so it looked like it was like from like a long time ago, so I was like, it's not like really nice, so like, well, so yeah, some of my spreadsheets are like really nice. Really got letterhead. No.
What is there's a sign-up sheet. I'm assuming they want us to sign. If you want to come up here and sign, please.
It doesn't matter, yeah. Could have been a better spot.
I have no idea.
Hi, how are you?
How are you?
Good.
No, we weren't, because remember, my trigger words were when I was saying how they were going to get through us. Okay, right?
Thank you.
Spot them. Yeah, spot them. But then everything I read after that is where my, because I was already imagining my picture what it was. That's how I wrote mine. And the more I read there, but then I got nervous. If the writer wrong, I missed it.
Coming in, there's a handout in here.
For you to grab it. So I did another contract. I had done one
Get them away.
One of their answers, I saw on their table answer, I didn't agree with. I was like, there's no way. They asked me like 5 questions. And I read a contract.
That's so awkward. You could have been like, you're like, I'll go at the dog. It's kind of obvious.
You'll remember the name. Oh, when I did it, I did all that.
No, it's okay. You don't even apologize.
Anyway, I'm also going to
My aunt is so embarrassing. Oh, yeah, you're all done.
Oh, that's right. And they didn't change it. So then I thought maybe I'm reading the self-assessment. So then maybe I'm reading the assessment. Like how they're doing you guys are involved. But I couldn't even I'm frustrated because I thought I thought it was rejection because it seemed so different from what yeah, I'll do it, but yeah, it was like, you know what, I really need this much more money and it's gonna work for me, and I wrote back and like, no. I need to go
So I got nervous because I meant to reply. Yeah, exactly. Taylor's in the law that they're looking for, and I don't know how this is going to go. Because right now, when they're scoring our card games, we miss. It's not the long ones that we get argued on side.
Right.
Three years later, I'm here.
I'm wondering if like maybe if I brought up yeah, apparently because I finally was like, I don't even know. Yeah. You have to put your hand over the realize and way to keep more like that's what I'm saying. Yeah. I don't know if I'm sure with you.
I may be back, but
Not today. Everything helps. Like now it's just like, okay, it's fresh in my mind. Now I put it on. I don't come out. Right. After I went yeah, we should have So for them to implement that, I'm like 19 and 20.
Anyway,
Well, and I've been doing that for years.
so anyway, but she all day away, but I want to know how now I feel like one of the things
You get it out of your eyes.
And they got home.
right. Okay, all right.
Yes, well, but they also have
Feeling.
Did everybody get a handout?
And did everybody sign in?
Yes. I have to if you want to eat.
All right, good morning, guys. Thank you again for coming out. Today, Professor Kinsley is going to do our common law workshop. But before she gets started, I wanted to remind you of some additional resources. Adapt-A-Bar focuses on the MBE. So if you're weak in that area and you're looking for an additional study aid, you can use this coupon code to get a discount. Another good resource is PMBR that also focuses on the MBE. There are 2 programs with them. The first is just their 3-day program. The second is their 3-day program plus access to their question bank. And these are the coupon codes for those as well.
All right. Good morning, everybody. You guys look functional, which is good. Want to start off just with a couple of maybe just check-ins to see how everybody's doing. So I've actually corresponded with a couple of you already. Just want to emphasize how important it is that you are keeping up with whatever bar study course you are taking. So we have lots of data in the law school, and I'm not a math person, so I have to get somebody else to tell me what it means, but just so you guys know, our data shows that there is a huge correlation between the effort that you put into your study and your chances of passing the bar. And that makes total sense, right? We all know this. The more you put in, the more you get out. So please make sure that you are keeping up with that course content. You've probably done enough of it by now to see that you really can't get caught up if you get too far behind. It is a lot of content. You are literally training for a marathon. So make sure every day you are doing the work that has been assigned to you. I cannot emphasize the importance of that enough. And hopefully for those of you who are doing what has been assigned to you, you're seeing that really this isn't rocket science. It's really not that hard when you break it down. It's just big. It's just a lot, right? A lot is being thrown at you. It's a lot to memorize. It's a lot to digest.
But from question to question and principle to principle, it's not that hard. So the best thing I can tell you is put the time in. And I know because you're here that you're at least doing that today. So thank you for making that commitment. We're going to talk about con law specifically, but I do want to give you a couple of test-taking tips before we dive into the actual substance of con law. So one place that students we know get really tripped up, especially in the multiple choice environment, is when you come to a question and you are like, oh crap, I've never heard of these words before. I don't know, like this is all, like this could be in Russian to me. I have no clue, right? And especially in con law, and we're going to talk about this, that's going to happen because you only study about a third of the Constitution in law school. And Barbary and Kaplan and Themis cover the same content that you learned in law school. That means there's 2/3 of the Constitution that you might have no clue what it says. That is okay. Do not stress. Nobody gets all 200 questions right. They don't. That doesn't happen. There's no person that gets every single question right on the bar exam. So the first thing you need to do is identify what you do not know. Okay? Identify what you do not know. When you get to a question and there are words in there or principles in there that you've never heard of before, you've never seen, you don't know, do not freak out. Just tell yourself, I don't know this one. Never heard of that. There's a couple things you can then do. You can either just randomly pick one. You got a 25% chance of getting it right. Or you can go to logical reasoning. But if you go to logical reasoning where you're trying to eliminate ones that seem wrong, make sure you're doing that with the understanding that you don't know the answer. So if two answers, if A and D look kind of alike, they're probably not the answer, right? If B and C say the complete opposite thing of one another, it's probably one of those, right? So if you can eliminate some and get down to where you're improving your chances to 50-50, great. If you can't do that, pick one and move on and do not stress. A lot of students get very tripped up mentally when they come to that question and they don't know what the question is about. You have to resist that trap that the bar examiners are throwing to you to trip you up, because we see patterns in our data where students encounter a question that is like very confusing to them and they start to miss a bunch after that. Because your confidence goes down, you can't let that question go, right? Have you guys experienced this in your prep? Yes. Okay, so this is the best thing I can tell you. Pick one and move on. Don't worry about it. Remind yourself that if you don't know the answer and you've never heard those words, everybody else feels the exact same way. Everybody who takes con law learns the same stuff. Everybody who's doing Barbary or Kaplan or Themis is learning the same stuff. So if you don't know the words, they don't know the words either. Don't worry about it, okay? And you're going to see, I think, some questions like that today. So you'll have a chance today when we get to the practice questions to try this out. Pick an answer, move on, don't worry about it. And this is definitely going to happen to you in con law. I can guarantee you that there will be a question on the MBE about con law that you will have never seen or heard of before. Probably just one. Don't worry about it. You can miss a question. No big deal. Okay? The main thing with con law that we want to do is focus on memorizing tests. So the con law questions are very tied to your memorization of these specific words that are in the test. So I think con law, maybe unlike some of your other subjects, is imprecise. Think back to what you talked about and learned in your con law class. Things like personal autonomy, individual decision making, powers of Congress. These things are sort of wishy-washy. Reasonable people can disagree about outcomes, right? I think if we divided the room on some con law topic, and there's lots of them in the news right now, we would probably no two of us would see it exactly the same way. So it's very hard to test that kind of subject in a multiple choice question. So the questions are typically not about outcomes. They are about you remembering the right term and applying it correctly to the fact pattern. So think about our scrutiny test, strict, intermediate, rational basis, and think about how similar those tests are, and really it just comes down to changing up a word here and there. Compelling interest versus substantial interest versus legitimate interest, right? You've got to know that cold. Don't trip up on those words, okay? So that is the crux of con law, is just memorizing all of these tests cold to the word, okay? And I'm going to try to help you do that today with the handout that I've given you. The other thing I want to say about con law, too, is that it is about powers. So think about all of the players in our government as being superheroes who are given certain powers. And one superhero can sometimes beat another superhero, and one superhero can sometimes not beat that other superhero. So we're going to put everything in that context. This is Superman versus Batman versus Spider-Man, okay? Very easy to think of it that way if you break it down, okay? That's all we're talking about, is who's in charge, who wins, what their superpower is, and when the superpowers face off against one another, who wins. That's it. That's all we're doing. All right, let's dive in. I've given you a handout. We're going to go through this together and fill this in. Feel free to raise your hand if you have questions. I want to be clear that this is not everything in con law. So we only have an hour to go over this. Oh yeah, come on down if you haven't gotten a handout yet. We only have an hour to go over this. Less, because I've just talked a bunch. So this is just a snippet. This is just highlights. Feel free to add notes on here as we go through this and also to ask questions, but recognize that we're doing big picture here. Okay, so the first superhero that we're going to talk about is Congress. So we see here A1, congressional powers. So we remember from our con law class that Congress has a lot of power given to it in the Constitution. The first, biggest, most likely subject of a question for you is the Commerce Clause. That is a power that the Constitution gives to Congress. Under the Commerce Clause, there are 3 areas where Congress can regulate. One is channels of interstate commerce. When we talk about the Commerce Clause, remember that we're talking about interstate commerce. So commerce that crosses state lines, commerce that involves people or things in multiple states. I think it's super hard to envision intrastate commerce. Like, I don't even know what that would be in today's day and age. But recognize that I don't know, if these bar people can come up with some really great hypothetical that's just commerce in Kentucky and doesn't involve anything else, anywhere else, that doesn't trigger the Commerce Clause. Interstate commerce only. So channels of interstate commerce, what is that? That's the movement, the places where commerce moves. That's rivers, that's roads, that's train tracks, bridges. You could argue the internet. Okay? Second, instrumentalities of interstate commerce. What's that? That's the stuff. That's the products. That's the pieces of paper. That's the computer products. That's the widgets. That's the food. That's the human beings and the factories that are producing the widgets and food. It's the stuff that's in interstate commerce. Unlikely to get questions on 1 and 2 because they're pretty straightforward, but make sure you know them. Number 3 is where the questions are likely to come. Number 3 is economic activities that substantially impact interstate commerce. There's a handout down here if you want to come grab it. So that's economic activities that substantially impact interstate commerce. What's this stuff? So remember that wheat growing case from your con law class where the farmer was growing wheat and he sold some of it and he ate some of it for himself? Even the wheat that he ate for himself was an economic activity that substantially impacted interstate commerce, because if he ate his own wheat, he wasn't going to go out and buy somebody else's. So think of how broad that power is, right? Even what I grow in my own backyard can substantially impact interstate commerce. Now notice that there's the word economic in there. So it's an economic activity. It's something I'm doing for commerce, or doing that replaces commerce. Two places where the Commerce Clause does not apply. Domestic violence. Anybody remember the second one? Big important case from con law, but I know it's a long time ago for you guys. Anybody remember? Guns. Yep, gun ownership. Domestic violence and gun ownership do not fall under Congress's Commerce Clause power. Now, you may see a question that will try to trip you up about this. What those two exceptions mean is that Congress can't justify regulating under the Commerce Clause, but they might be able to justify regulating in those activities through some other power, right? They can spin their way into regulation about domestic violence. They could maybe tax gun ownership, right? They can use some other power. They just can't use the Commerce Clause power, okay? Any questions about commerce? All right, let's get to the little baby stepchild of the Commerce Clause, which is the Dormant Commerce Clause. Very important that you know in a multiple choice question situation that the Dormant Commerce Clause is not in the Constitution. Do not pick an answer that says there is a constitutional right to the Dormant Commerce Clause. Nope. Not in there. It's implied. What is the Dormant Commerce Clause? First, it applies only to state regulation. Does not apply to the federal government. So don't pick an answer that says Congress violated the Dormant Commerce Clause. Nope. Only pick an answer that says the state of Florida violated the Dormant Commerce Clause, right? Only applies to state government. Number two, cannot discriminate against out-of-state commerce. So states can't say, we only sell Kentucky soap in Kentucky, right? Can't discriminate against things coming into the state from out of the state. The test. You weigh the burden on interstate commerce against legitimate local benefits. Balancing test. If maybe all we're doing with our soap regulation is keeping one artisan soap maker in California from sending her products to Kentucky, maybe that's not such a big deal. Especially if we're protecting Kentuckians from allergens or something like that, right? And then lastly, the market participation exception. So this one is kind of confusing. You might see a question about it. Don't worry if you don't understand it. What the market participation exception means is that when a state becomes a business, it can discriminate against out-of-state commerce. So if the state, let's say, Kentucky is a good example. Kentucky state lands have coal in them under the ground. if Kentucky sets up a business to mine and sell its coal, it can say, we're only hiring people who live in Kentucky to mine our coal. Or we're only selling our coal products to factories that hire Kentucky workers, right? So if the state becomes a business, it gets to discriminate. Make sense? Okay. For questions like that, you want to look for, the triggering fact you want to look for is that the state owns the property. So if you see something like, Alaska owns forest trees that it is selling to timber companies, or Florida owns orange groves that it is selling to Tropicana, or something like that. You want to look for the state owning the property. That would be a trigger for you that the market participation exception is going on. All right, taxation, another superpower given to Congress. Few words about taxation. First, the primary purpose must be to raise revenue. So the government has to be acting with a motive to bring money in. Secondly, must be uniform. So Congress cannot say all women are taxed for X, or all school teachers are taxed for Y. The tax must be uniform across groups and transactions. Third, the tax cannot be punitive. This is really just another way of saying that the primary purpose must be to raise revenue, right? If Congress decides to all of a sudden tax all felons for their use of the internet, maybe that's intended to be punitive. That would be invalid under the taxation power. And then lastly, Congress cannot tax state and local government. Separate sovereigns. So let's say, blending concepts, that the state of Florida is going to sell its oranges to Tropicana and make a lot of money. And the state of Florida is using that money from the sale of its oranges to fund its new college scholarship program. Guess what? Congress doesn't get to tax the revenue that the state of Florida made from selling the oranges. Okay? All right, spending, another power that Congress has. The spending power is conveyed to Congress through the General Welfare Clause. This is a place where the bar examiners try to trick you. A big one. Congress does not have a general welfare power. So Congress doesn't just get to do what it wants because it thinks it's in the best interest of everybody. Right? That is not a power that Congress has. Congress doesn't have a health and safety power. It doesn't have any of those things. It can only act for the general welfare by spending money. Don't mix that up. The General Welfare Clause is only about spending, nothing else. There must be money tied to it. Secondly, when Congress spends money, it cannot coerce states into complying. So Congress is free to make up programs, and they do this quite a lot. Like, hey, states, we would like to deal with the mosquito infestation problem that's causing a lot of people to get some bloodborne disease. And so we're going to give you a grant of $20 million per state if you use this specific chemical and spray it so often and test all of your citizens, et cetera, right? And hey, guess what, states? If you don't do our mosquito program, we're going to pull back some of your health care funds. So it's carrot and stick. Cannot be coercive. How do we know when it's coercive? It's when the state doesn't have a choice. When it's going to lose a whole lot of money, and not in dollars, in percent. So trigger for this, and how you will know that you are being asked a question on this principle, is when the question tells you that some kind of funding is X% of the state's budget. When you see the word percent dealing with Congress, start thinking spending power. If the state's going to lose 0.05% of its budget, that's not coercive. They can make that up some other way. If they're going to lose 50% of their state budget, that's coercive. Okay? So you're looking for the word percent. All right, hiring and firing. Oops, we've skipped one, sorry. Property clause. Congress gets to make regulations and do whatever the heck it wants to with respect to its own federal property. This applies only to federal property. So if Congress wants to say, we're making a closing time of 6 p.m. in all national parks, fine, no problem. That doesn't mean that Congress gets to say all state parks have to close at 6 p.m. too, right? Only applies to federal property. Hiring and firing, another kind of power. So this is a shared power between Congress and the executive branch. The Senate gives advice and consent. Those are fancy words just meaning they confirm somebody. We know what that process looks like from the news, right? The president nominates somebody, the Senate has a bunch of big hearings, they're on TV, everybody gets riled up, then they vote, right? We know what this is. The term for that is advice and consent. Only by the Senate. The House doesn't get a role in that. Okay, only the Senate. And you may see questions on this, where maybe the House votes against someone and the Senate votes for someone. Is the person seated in office? Well, who cares about the House? They don't have any power, right? And then impeachment, also an activity of the Senate, 2/3 vote. You may see a question on this too. All right, potential traps, we've talked about a couple of these. So you will most definitely see answers to questions about Congress and Congress's authority that talk about public interest, public safety, general health and welfare, things that sound like really good ideas, right? Things that are like, oh, yeah, they're protecting people. This sounds really good. Do not pick that answer. Congress does not have a for the good of everybody power. Congress can't do something unless the Constitution specifically gives it that superpower. Okay? So do not give Congress the best interest of the whole wide world superpower. They don't have it. Secondly, don't mix up federal and state powers. You will also see questions where they're trying to give the Commerce Clause power to a state. Nope. Or where they're trying to give the federal government some kind of power that usually states have, like regulating family relationships or something like that. Criminal law, right? So you have to know which powers match up with which branch of government. If you can master that, you will get these questions right. Okay, congressional power boosters. So these are things that are not actually powers themselves, but that make Congress's power stronger. 1, the Supremacy Clause. This means that in a fight between the federal government and the state government, the federal government always wins. The Constitution, acts of Congress, court decisions from the federal government always trump whatever the states are doing. As a part of that, we have the preemption doctrine. This is how we decide if the federal government and the state government are even in a fight with each other. Right? There's two kinds of preemption. There's express preemption. This one you likely will not see a question on because it's very easy. There's no gray area. So express preemption is when Congress says, we preempt. We are in charge of this field. States, you can't do anything about it. You're not going to see a question like that because it's very obvious. The second kind is implied preemption. This is where Congress takes an action that is so broad and comprehensive in a particular subject that it implies that Congress intended to keep all the power for itself and give none to the states. Three things you should be looking for implied preemption. 1, federal law and state law conflict. 2, the state law frustrates the federal law, makes it harder to accomplish the federal law. 3, Congress takes over the whole field. Are these sounding familiar? Okay. An example of this would be where Congress passes a law, pick a topic, auto emissions. Congress uses its Commerce Clause power to regulate the emissions that come from cars and to create emission standards. Well, if California has already had a regulation about that, too bad. Now there's a conflict, federal government wins. States can make harder regulations. They cannot enforce easier regulations. Okay, so that's important too. Let's say that Congress set the emission standard at, I don't know how they measure that, 50. At 50. Well, California can't say, we want 30. But they can say, we want 95. Okay? Making sense? All right. The next power booster, the necessary and proper clause. Once Congress has a power, it can do anything that's necessary and proper to exercise it. The necessary and proper clause is not itself a source of power. Do not pick that answer. If you see Congress passing a law, doing something, and they say, which is the best source of power for Congress's action? It ain't the necessary and proper clause. That doesn't give Congress power. It's just like the super rocket booster, right? It lets them do everything they want to do once they have the power. And then D, intergovernmental immunity. Yeah.
So in a multiple choice question like that, would you want to say like the Commerce power only, or Commerce Clause only, or Commerce Clause plus necessary and proper?
That would depend on the facts of the question, and I've never actually seen a question written like that.
Okay.
They're probably not going to try to trip you up like that. What you'll see instead is Commerce Clause, necessary and proper clause, spending power, general health and safety power, right? You're not going to pick general health and safety because I told you that they don't have that, right? And you're not going to pick necessary and proper because that's not a power. which is a power booster. Okay? Intergovernmental immunity. The state cannot regulate the federal government. So, National Park, Yellowstone, sitting in the middle of Montana. Guess what? The state of Montana doesn't get to tell the federal government what to do in Yellowstone. The fancy term for that, and you do need to know it, and you may not have learned it in common law, is intergovernmental immunity. Make sure you remember that term. All right, moving on to page 3. Congressional power limits. So there are some principles that take the powers that are given to Congress and make them a little bit lesser. Talked about powers, boosters, and now we've got power limits. A, commandeering. Congress cannot force action by state officials. Congress is not the boss of the Cincinnati Police Department. It is not the boss of the Kentucky governor. Congress doesn't get to tell state officials what to do. You may see a question like this, where Congress has this great idea and you're like, oh, yep, Commerce Clause justifies that. But then there's some enforcement scheme where they're saying the state insurance inspectors will go around and catalog everybody's insurance rates or something like that. Nope, can't do that. Cannot commandeer, cannot force the state officials to do anything. And then B, the 10th Amendment. The 10th Amendment says that if there's a power that exists in the world and the Constitution doesn't give it to Congress, it goes to the states. So remember I told you that Congress does not have a general health and safety, best interest of everybody power? Guess who does have that? The states under the 10th Amendment. All right, any questions about Congress? Okay, let's move on to the executive branch. Powers given to the president and people acting under the president. Veto. But no line item veto. This is an all or nothing power. So the president can say, this bill sucks, tear it up, not signing it, or he can sign it. That's it. Those are his two choices. He doesn't get to cross out the parts he doesn't like. Or she, maybe someday. Number 2, the president can make appointments with the advice and consent of the Senate. So the president gets to hire people. You can draw upon your knowledge from being a human in the world and watching the news to tell you what kinds of people the president gets to hire. He gets to hire the Supreme Court. He gets to hire the Attorney General. He gets to hire his cabinet members. Guess who he doesn't get to hire? Congress, right? The people hire Congress. Make sure you know those distinctions. Number 3, he is the commander-in-chief. He's the boss of the military, but he cannot declare war. Even though we didn't talk about it, that's a power that Congress has. Make sure you know the difference. The president can deploy troops. The president can tell the troops, we're going to strike at dark 30. But he cannot declare war on a foreign nation. Number 4, foreign policy. So the president gets to negotiate treaties. He gets to set up meetings with diplomats and go around the world and be the official voice for the United States. And then 5, the president has the power of recognition of foreign states. So the president gets to decide, for example, what the capital of Israel is, or who the president of Venezuela is. He has the exclusive power to recognize other countries and their leaders and their structure. Any questions about the president? You'll probably see fewer questions about executive power because it's tough to test. More questions about Congress. All right, judicial branch, our last superhero in the triumvirate of the federal government. So there's some limits on judicial decision making, and this is where you're likely to see a bunch of questions. So times when the courts do not get to decide cases, times when the courts do not have power. One is standing. Standing is when the court decides that the person in the court does not have the ability to be there. 3 components. 1, injury in fact. So the person standing in the court must be injured or imminently injured.
Is that 2? Is that 2?
No, that's still number 1. 1 is injury in fact. And just make sure that you understand that injury in fact includes injuries that are very much about to happen, definite to happen in the next few days, weeks, months, kind of thing. So people can go to court and say, Congress just passed this law, and it's going to apply to me soon, and I'm going to be really injured by that. That's enough to be an injury. They don't have to come in with a broken leg, okay? But what they can't say is, I might be injured. Or if I do this action later, then maybe I'll be injured, right? It cannot be speculative. Has to have happened or be imminent. Number 2, causation. The act of government must have caused the injury. You know a lot about causation from other classes. The if, but, all that, right? All that stuff comes into this causation requirement. It looks the exact same. So you can import all your torts knowledge into this requirement. And then lastly, redressability. So the court has to be able to do something about the injury. Either through money or by telling the government to stop it. If there's literally nothing the court can do, then standing is not satisfied. All right, B, ripeness. This is where the injury hasn't happened yet and seems pretty far off. This is where the apple is just a seed. We gotta wait to have an apple before we go to court. This one's pretty easy to spot. I think you'll know when you see it. C, mootness. Mootness means that the injury happened and got fixed already. There's an exception to mootness, which is for cases that are capable of repetition but evade review. Things that by necessity happen in a very short period of time, so short that a case cannot be fully litigated by the time the injury is over and has already been fixed. Classic example of this is abortion. Anything related to pregnancy. Takes 9 months, maybe 10, maybe 8. Short-term situation. You cannot litigate a case all the way to the Supreme Court by the time a baby's born. You can't do it. So that's the classic example. That's capable of repetition. It's ongoing. It's going to be experienced again, and the courts can't act quick enough to address it. Okay? D, independent and adequate state grounds doctrine. This draws a little bit from Civ Pro. You may have covered some of this topic in Civ Pro as well. The federal court does not have jurisdiction to resolve a question where the decision of a state court rests on an independent and adequate state ground. So, let's say somebody's in state court. Let's pick the Kentucky Supreme Court because we're here. And they are litigating a question that has a federal claim and a state claim. And the Kentucky Supreme Court says, we're not sure about that federal claim. We don't really know. You might win, you might not. But no matter what happens with that federal claim, you lose the state claim. You lose. There's no way you're going to win the state claim. You're out. Guess what? The U.S. Supreme Court is not going to hear that case because the decision rested on an independent and adequate state ground. Yeah.
Or is that inadequate or inadequate?
Independent and adequate. Yeah, thanks for clarifying. Yes.
They wouldn't hear the federal part of that?
Correct. Correct. Because the litigant loses the state claim, regardless. So there's an independent basis for the litigant to lose. Does that make sense?
Kind of.
This is a little tricky. You'll know you have a question dealing with this when you see a person raising a federal claim and a state claim. You'll increase your chances of getting the question right if you can do that. If you can remember, federal claim and state claim, that's independent and adequate state law ground. Okay? Because you're at least going to see two answers and maybe only one. So you're going to increase your chances just by spotting that that's the problem going on. That's a lot of what mastering these multiple choice questions is about, is just identifying what the issue is. And if you can do that, you're going to get the right answer. I saw another hand. Yeah.
So if you have you've got a state claim and then you have like a federal question, but you choose to litigate in state court, and the state says no, you're not going to win, then you can't. Then the federal question dies there.
Yes.
Is that what you're saying?
Yes. Yes. That's a good way of putting it. Yes. It's just another way that the federal courts lose power because the state has taken it. Okay. All right, political question doctrine. Another set of cases that the federal courts are not going to hear. And these are questions that are not really legal, they're more political. They're better resolved by a different branch of government doing their own political thing. So, for example, yeah?
Can you say what it was again? Was it just political question?
Political question doctrine, political question, yeah. So these are things like, this is a horrible example. You would never see this on a test, but this is the best thing I can think of to explain to you. Like, if the Democratic Party got together and said, like, we have 87 candidates for president, and we think the best one is Joe Biden, so we're going to go with him. Well, Beto O'Rourke doesn't get to sue the Democratic Party in federal court to have the federal court decide that he should be the candidate. That's a political question, right? That's a question of politics, which candidate's better for a particular, to run for a particular position. Yeah.
This might be a little off topic, but if he meets the requirements to be president, is that necessarily a political question?
Yes, it is. That is necessarily a political question. Now, it could become not a political question if he says, I'm being discriminated against on the basis of my religion or something. Or if Cory Booker was not the nominee and he said this is because this is racial discrimination, then he would have a claim, right? Because that's tethered to the Equal Protection Clause, not just I want to be president. The I want to be president questions are political questions, okay? All right, F on page 4, the 11th Amendment, another way that the federal courts lose power. So do you get the overarching theme here? When we're talking about Congress, we're talking about powers they have. When we're talking about the courts, we typically talk about powers they don't have. Lots of ways for the federal courts to lose power, many ways for Congress to gain power. Keep that in mind as you're trying to choose the right answer. 11th Amendment. So this bars suits for money damages against state officials in federal court. Although you may want to, you cannot sue Governor Bevin for money in federal court. But the 11th Amendment does not bar injunctive actions against state officials. So if you want to sue Governor Bevin in federal court to stop him from doing something that is unconstitutional, you can do that. 11th Amendment immunity can also be waived. So if Governor Bevin said, I see your lawsuit, I'm going to take that on, no problem. I'll show up in federal court so you can sue me for my money. That's okay. Any questions about the court system? Yeah.
Where do Section 1983 actions come in with regards to
what we're going to talk about next? Individual rights. So we've talked about the three branches of government. 1983 lawsuits, by the way, that's the statute that people use to sue in federal court to enforce their constitutional rights. So we've talked about the three superheroes of the federal government: Congress, the president, the courts, right? There's another player in this. There's another dark horse superhero coming in, and that's us, individuals. So we're not a branch of government, but the Constitution spends a lot of time giving us rights, giving us powers, right? So let's talk about that next. This is not an exclusive list. So recognize, I said at the beginning, this is not everything in common law. There's a bunch we're not covering. Same for individual rights. So there are other individual rights besides what we're going to talk about. These are the big ones and the ones you're more likely to see questions on. First, freedom of religion. Two components to the freedom of religion. One's positive, one's negative. One gives, one takes away. Okay? Important that you know that. First, the Establishment Clause. This is the negative side of the freedom of religion. This is sort of the freedom from religion in some sense. This is the church and state separation component of the freedom of religion. 3 factors. A law that blends the government and the church must have a secular legislative purpose. You are likely to see a question on the bar exam testing the Establishment Clause that deals with schools. So if you see the government giving money to a private school, a religious school, something with kids programming, start thinking Establishment Clause. That's the area where this is most often tested. So I'm trying to give you these tips, it's knowing the law and then it's knowing how they test this, right? And I want to help you quickly identify, because that's key. These questions are dense and a lot of people don't finish them all. And so the better you can get at quickly identifying oh, I see a kid in school, a church, money, that's the Establishment Clause, right? So getting familiar with how, the fact patterns of how they test these questions is really important. This is a question that typically deals with schools. Secular legislative purpose for the spending or the program or the money. B, the primary impact does not advance or inhibit religion. and see that there's no excessive entanglement between the church and the state. Here's an example. Let's say the state of Kentucky wants to improve physical fitness among its elementary-aged students. And so it comes up with a curriculum and some benchmarks, and you're going to do that eraser run thing, and they're going to measure you and whatever, and you need a certificate. And they come up with this program, and they spend $30 million, and they hire a bunch of teachers that they're going to dispatch to go out in the schools and do these activities. And included in that $30 million is money for the teachers to go not only into the public schools, but to go into the Catholic schools too. Is that okay? Probably, yeah. Secular legislative purpose, yes. They just want to make kids physically fit. The primary impact to neither advance or inhibit religion, yeah, it has nothing to do with religion. And C, is there excessive entanglement? Not under what I've described to you. Program is looking the same between the public schools and the religious schools, right? That's okay. Flip it around and say, the state of Kentucky has decided that, the meals that are served in Catholic schools are less healthy for school children than the meals that are served in the public schools, because the public schools are under the Department of Education program where everybody gets an orange and a chocolate milk, right? So now the state of Kentucky is going to spend that $30 million only in the religious schools just to provide food to students who go there. What do we think about that? Or what if the state of Kentucky says, we are very philosophically opposed to kosher diets. We don't like kosher diets, and we're going to make every kid in a Jewish school in Kentucky eat the orange and the chocolate milk and cheese or whatever to make it not kosher, right? That looks different. Okay? So keep an eye out for school fact patterns. And remember these 3 parts of the test. Then the second component of the freedom of religion is the free exercise clause. This is the positive side of the freedom of religion, and it means that you, me, and everybody else, we get to do our religion regardless of what the state says. So Congress cannot say, it's an extreme example. Churches are illegal. Synagogues illegal, mosques illegal, right? We don't have that. We have the right to exercise our religion. Freedom of speech is next. We typically see a good number of questions on the freedom of speech on the bar exam. It's easier to test because it's less willy-nilly than some of the other rights. So make sure you know this stuff cold. Here's where the words really, really, really matter. So make sure you know these tests verbatim. There are a couple of different kinds of speech restrictions, and it's important that you be able to identify when a speech restriction is a certain kind and then how the test kicks in. So first, we're going to talk about the strict scrutiny regulations, content-based restrictions, and prior restraints. Content-based restrictions are where the government restricts speech because of what it says. We don't like speech that is against a government program, so we're going to outlaw that. Or we don't like speech that is about the right of pro-choice. We're going to outlaw that. Or maybe we're not even going to outlaw it. We're maybe just going to put a little restriction on it. Like, You can say this, but only between the hours of 9 and 5. Prior restraints are when the government makes you ask for permission before you get to say something. Trigger word here in a fact pattern would be license or permit. So if you see a fact pattern where the government is setting up some kind of licensing scheme for you to be able to say something, like if you want to open up a magazine shop, you have to go and get a permit first. If you want to have a rally in a public park, you have to go and get a license first. It's a prior restraint. Make sure that you know how to identify those two types of regulations of speech, content-based and prior restraint. If you have those things going on, you get strict scrutiny. What is strict scrutiny? The regulation must be the least restrictive means of achieving a compelling government interest. Don't mix up those words. Least restrictive means compelling government interest. Then we get to time, place, and manner restrictions. This is where the government is saying, you're allowed to speak, but only at this time, only in this place, or only in this way. These get intermediate scrutiny. They must be narrowly tailored to a substantial government interest. Again, don't mix up compelling and substantial. They sound kind of close. Important you know the difference. Page 5. The right of free speech includes the right of expressive conduct. Examples: flag burning and nude dancing. Nobody's saying anything, words aren't coming out of anybody's mouth, but these activities convey a message and therefore they fall within the right of free speech. Number 4, sexually oriented speech. There's something called the secondary effects doctrine. This means that governments can regulate the location and operation of adult businesses if they're targeting the secondary effects, things like crime, traffic, litter, etc. Not the content of the speech, because remember, if we have a content-based restriction, that's strict scrutiny, and those are usually bad. Secondly, the Miller test for obscenity. I'm not going to give it to you because it's long, but you need to know it. Number 5, speech by government officials in furtherance of their official duties can be regulated. So if you see a fact pattern where a police officer in the course of his official duties is saying something that he gets in trouble for, don't tell me he has a First Amendment right. He doesn't. Equal protection. We're going to run through this stuff real quick. Krista, how am I doing on time?
We're right at an hour.
Okay. We'll run through the rest of the outline, and then I'm going to let you guys have a chance to do your practice questions, and we can go back over anything we might have missed after you do the practice questions. Equal protection. So protected classes, race, ethnicity, and alienage. They're reviewed with strict scrutiny. Strict scrutiny looks pretty much the same as it did in the First Amendment context. Once you know the test, it applies across the different rights. There is an exception for discrimination against aliens in performance of critical government functions. So while the state of Kentucky cannot say, we only let citizens attend our schools, they can say, we only let citizens teach in our schools. That's a critical government function. Gender discrimination is reviewed with intermediate scrutiny. So make sure you know the difference. Race, ethnicity, and alienage gets strict scrutiny. Gender gets intermediate scrutiny. And then all other class distinctions, all other times that the government is regulating different groups differently, that gets rational basis review. Which means that the restriction must be rationally related to a legitimate government interest. So look at the layers: compelling, substantial, legitimate. Make sure you know those. The takings clause: no government taking of private property without just compensation. So guess what? The government can come in and take over your house. They just have to pay you for it. They have to pay you fairly for it. In this area, it's important for you to know the distinction between physical takings and regulatory takings. You may cover some of this in your property class or property lecture series as well. A physical taking is obvious. It's where the government is coming in and usually sticking something on your property or putting something through your property, a cable line, a water pipe, a light pole. A regulatory taking is where the government says, you can't do this, and you can't do that, 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 and you can't, all these things, and all of a sudden you can't do anything with your property. Physical takings are almost always unconstitutional. Regulatory takings are almost always constitutional. Remember the South Carolina beach case where the guy's house was on the beach and he couldn't do anything with it? He didn't win. So regulatory takings are really hard to meet. Don't pick an answer that says, this is a regulatory taking and it violates the Fifth Amendment. No, that's probably not right. Privileges and immunities, two different kinds. Don't mix them up. One of them conveys a strong right to people, and one of them doesn't convey much of a right at all. You probably remember this from con law. The 14th Amendment kind. This applies to individuals only, not corporations. And this is the weak one. The only thing that it has ever applied to ever in the history of the universe is people moving from one state to another and their welfare benefit gets reduced or taken away. That's it. So chances are, if there's an answer where it's saying what is the strongest right, this is 14th Amendment, privilege and immunity is probably not it. The other kind is the Article 4 kind. This one's stronger. This means that states cannot discriminate against non-citizens in matters of fundamental rights. Remember in this context that the term, quote unquote, fundamental rights is bigger than the Constitution itself. So these fundamental rights are not only your civil rights, like your First Amendment right, your freedom of religion right, all that stuff, also your economic activities. Due process, really quickly, two kinds. Substantive due process. This protects fundamental privacy rights. This is the loosey-goosey one. Who the heck knows what that means, what privacy means, right? You probably spent a lot of time in your common law class trying to figure that out. Here's a few things that we know it does mean. A, your right to an abortion. Remember the undue burden test. So restrictions on abortion, including regulations of abortion clinics, time, place, things that are said in there, all that stuff. Cannot impose an undue burden on the right to obtain an abortion. B, marriage. We know that the right of marriage includes not only my right to marry a man, my right to marry a woman as well. C, child rearing. Parents have a constitutional right to make decisions about how to raise their kids. D, contraception. Remember these cases, Griswold, etc., where people could go to a pharmacy and buy birth control pills, condoms, etc. That's all protected. E, personal health care decisions. Notice I said personal. I don't have a constitutional right to make your health care decision. I only have a constitutional right to make mine. And if that healthcare decision is maybe not the one you would make for me, that is okay. I can decide I don't want treatment. I can decide I don't want to be resuscitated. Personal healthcare decisions are protected. What does substantive due process not protect? What is not included? Assisted suicide and grandparents. Grandparents do not have a fundamental right to have a relationship with their grandkids. While I do have a fundamental right to make healthcare decisions for myself, I don't have a right to kill myself. Okay? The second kind of due process, procedural due process. The important components here are notice and an opportunity to be heard. The government can't affect my liberty, my property, without giving me notice and some kind of chance to stand up for myself. Some process where I can go, some appeal, some something, okay? One last point about due process. The Fifth Amendment right of due process applies to the federal government. The 14th Amendment right of due process applies to the state governments. Make sure you know the difference. And then one last word about burdens. So in addition to knowing the test, you also need to know whose burden it is to prove that a right was violated in an individual rights case. If it's strict or intermediate scrutiny, the burden is on the government. If it's rational basis scrutiny, the burden is on the private party. So you may see a question that expects you to make a couple of logical leaps. First of all, what right is at stake? Second of all, what level of scrutiny do I apply? Third of all, who has the burden? Make sure you know who has to prove their case. All right, you ready to try this out? Take some practice questions? Yeah.
Up at the top of that page, B.
Uh-huh.
What are the blanks on that one?
Fundamental rights include economic activities and civil rights, and that's only in the context of Article 4 privileges and immunities.
Thank you.
You guys want to, does anybody need like a quick bathroom break? Probably. Yeah, all right, go. And come back quickly, like 5 minutes. I don't think so.
I always bring layers downstairs, and Ryan says he's dead.
Last week I brought in great. That would have put me to sleep. I would have never been able to.
Oh, it's hilarious.
I worked like 8 hours long. Look, it got cold. There were 3 Yeah. Yeah. That's why I'm going to share. I think they might be a little stale though. Like I put one in and I'm like, ooh, either I have too much water or.
You're like,
Why did it feel like cardboard? I guess because I get too She said she would pick
I'll be back in a little bit. Okay.
He's trying to keep short questions. So I've written some of those in the margin. Trying to keep 40 slides. He's right.
yeah.
Some of them have been wonderful. The guy just did, do you want to do it? Yeah. Oh my gosh. Did you do the criminal one? Yeah, that's the one I'm talking about. Yeah, I love that. I was like, after a while, things wore me down. I'm like, I've got to take a break from the criminal. And I'm like, that is ridiculous. Yeah. I mean, it helps. Yeah. But yeah, he was. That's me. I'm staying on the lecture. I feel like I'm passing.
Review every single thing.
No, I have to like review some of
If you and I'm like, well, did I read the first time?
you know, like,
So you just gotta keep going, just keep doing it.
that was me, and I would have gone back and
Well, that's why I'm like,
No, we looked into it. It's going to be like $40,000 to have somebody come in. And my dad's an engineer, and he works in a place a lot of other. He's not structural engineer. He was just asking me structural math. What do you think?
initially, my goal was to give my answer and it didn't work out.
Yeah.
And actually, for me, because it's such
oh, it takes me 3 times long.
It takes 14 hours to get through everything I'm doing.
No,
Right. And then if you go back, you're like, she's
oh, yeah. I haven't done her comments though,
I know. Those are the only that I have. I obsessed
oh, you think they're all.
So I'm obsessed about and then I used to well, okay. Yeah, it's fine.
So I get to the all the way down. Every time I think like a lawyer.
Okay, has everybody signed in? No.
We're no longer friends.
If I see your mom, I'm gonna let it talk. Everybody back. Are we missing anyone? I need to do it. I don't have to write. I don't know. Yeah, right. I kind of feel like
I'm not missing it, but I didn't know that you had it.
I got mine. Yes, but still,
Really, I'm not missing it.
I ran out of grade.
I'm not thank you. I'm not missing it.
Yeah, but
All of them? What? But like that. I bet you pencil thing on my counter.
oh, I gave it.
Well, I can't do it.
All right, is everyone ready? Everyone ready? You have 1 hour and you may begin.
don't you guys take like maybe 3 or 4 more minutes and then we'll reconvene?
That's what you go to.
It's like, oh, so now we have I don't know what things.
Maybe like 5 more minutes, I think. Because I remember.
Is anybody still working? Okay. Yeah, folks are taking a break, which is good. I'll try to track people down. If you guys know the missing folks and then want to text them, okay?
Did y'all get an answer?
I'll volunteer to say yes, I'd like to see the answers first.
I'll pass out the answers.
It takes me a minute just to number them so I know I'm on the right questions. Thank you.
Two people.
Who's the other speaker? Did you look at the go? September 1. Yeah. This is what you have. Now.
Shoot.
I know.
Okay, I know we're still missing a couple folks, so we'll just debrief for a second while we're waiting on them to come back. So how do we feel? Okay?
Still great.
Still working through it?
Just great.
Oh, okay, you guys got the answers?
Yeah.
Oh, I don't have to tell you the answers?
No, we
Okay.
love to talk about it.
Okay. All right, so go through and see what you got right and what you missed, and then we'll... So do you guys have this too, the, like, explanation?
That's what we
Oh, okay, great. I was like, where did the answers come from? Okay, so you have this document then. Great, okay. When you get done self-grading, will you put your pen and paper down so I can see that you're done? Yeah, these explanations are printed in reverse order. So you'll see the explanation and then you'll see the question. It is pretty tough to follow. Do you want me to call out the right answers for you?
Oh my God, yes.
Okay. All right, number 1 is C. Number 2 is C. 3, B, boy. 4, A. 5, C. 6, C. 7, B as in boy. 8, D as in dog. 9C. 10B as in boy.
Say 9
Yes. 11C. 12C. 13C. 14A. 15C. 16A. 17C. 18C. 19C. 20C. 21D as in dog. 22A. 23A. 24D as in dog. 25D as in dog. 26D as in dog. 27D as in dog. 28C. 29A. 30A. 31D as in dog. 32C. 33D as in dog. Okay, since you guys have the explanations, even though they're a little tough to read through, but you can take those with you, what I want to do instead of going through every question is to ask you which ones you were confused by, surprised by, and what you would like to talk through and go over more. But as you're processing that and thinking that through, let's just talk about the test-taking experience generally. So were there any questions or answers in this set where there were words or terms that you did not know? Did anybody encounter any of that? Abstention. Question number 1. There was a word in there we didn't talk about, right? How did you handle that? And that, you know what? Not to be harsh, but that's probably the likely outcome, right? If you don't know something, you don't know it. It's okay, right? No one is going to know every single thing. Not even lawyers who have practiced for 100 years and are the best lawyers ever are going to know every single thing, right? The most likely outcome is you'll probably get it wrong. Don't stress. You can miss a whole lot of questions and still pass the bar exam. So do your best and move on. Was everybody able to do that when you saw a word that you didn't know? Okay. How did we feel about the difficulty level of these questions? Were they confusing? I know you all finished on time, so time doesn't seem to be a problem. All right, are there specific questions that you have, ones that seemed more confusing than others?
Number 7 kind of seemed like that situation where it was all interstate commerce.
All right. Number 7 seemed like maybe it was intrastate commerce. This is the one where a state was saying you have to use the HIV testing facility in our state. You can't use an out-of-state. So first off, which branch of government are we talking about? And federal or state? All right. So what powers or restrictions apply to states? What do we have in our toolbox to deal with state legislation? Yes?
Dormant commerce.
Dormant Commerce Clause. Anything else that we could be thinking? What other concepts come up when we think about states trying to legislate stuff? Police powers, that's, yep.
Any powers that are reserved for.
Yep, 10th Amendment stuff. What else? I'm organizing this differently than the outline was organized for a reason. What else deals with state government?
Maybe privileges and immunities.
Privileges and immunities, yep. And there's one other one.
14th Amendment.
14th Amendment does, yeah, individual rights. There's one other one is when federal government and state government get in a fight. Preemption, supremacy clause, that stuff. So right away, when we see the state government taking action and we know it's a con law question, we want to go through our mental checklist. What do we know? What could this possibly be testing? Now, we do see that there's a possible discrimination issue going on here, right? Because the state is favoring its own commerce over commerce that's happening out of the state. What could that be? Could it be the market participation exception? No, because the state itself is not a business. We have private HIV clinics going on, right? The state isn't a business. Remember what I told you to look for the market participation exception when the state's doing something with its own property. That's usually the key, like they're selling their timber or their oranges or their coal under the ground. State's not selling anything here. That's good that we're thinking about that because we know that that applies to state government. What else, what other kind of doctrine do we have in our toolbox that deals with when states are discriminating against stuff out of the state? What is that? Interstate commerce, dormant commerce clause, right? Now, here's the trick, because this is what the bar examiners do. Oh, we know this is dormant commerce clause, but they don't put that in here, right? They're making you make the extra logical leap. Remember, the dormant commerce clause is not in the Constitution. It's implied in what? The Commerce Clause. There it is. Right? Now, let's talk about why these other ones are wrong. So, the contract clause, we didn't talk about that today, but is there anything in here that sounds like a contract? No. Nobody's formed a contract to do anything, so that's probably not it. We can just intuit that, right? There's no contracts going on, so why would the contract clause be a part of this? How about C? The statute does not discriminate against out-of-state competition. Why is that wrong?
Exactly what it's doing.
That's not the facts. That's not the facts they gave you, so we can cross that one out. And then how about D? The statute is valid under the police power because it's directly related to public health. Does that sound like maybe an okay answer? We know that states have power to protect the public health, right? What does that answer miss? What's wrong about that answer?
Does that come from the police power?
Good point. Yeah, good
That's
point.
why I didn't think so.
Maybe the power isn't specifically defined enough. Why else is it wrong? Even though state government might have a power, they're still subject to the Constitution. Their power is not unlimited. They don't get to do whatever they want. If the exercise of a state power bumps up against a constitutional right or provision, as it does here, the state can't take that action. So really, if we work through the process of elimination, we're really down to the correct answer anyway, even if we didn't know it. What else? Which other ones were tricky or confusing? You guys get the Miller test question right? the obscenity standard. I didn't give you the test, I was gonna say if you remember it.
We talked about
Number
number 10.
10, sure. Okay, this is one of those ones that blends constitutional law, civil procedure, conflict of laws, remedies, everything, like all thrown into one question. When that happens, your likelihood of getting it wrong goes up because you might think this is a con law question and somebody else might think this is a civ pro question. So don't stress. This is also a really long fact pattern. So what I would suggest in terms of test strategy is when a fact pattern is short, you can read it once. If a fact pattern is long, you're probably going to need to read it twice. So you need to exercise good time management in knowing, okay, when you eyeball this on the page, this is a long question, I need to spend more time on this one, okay? So to refresh everybody's understanding of the facts, Congress passes a civil statute about parklands. It's a civil fine mechanism. Somebody violates the law, they get the civil fine, then Congress decides the statute isn't working, and they have to increase the penalty and make it worse, and then they go back and they tell the guy, oh, your penalty is now worse than it was when we first gave you the fine and the order to stay out of the parks or whatever it was. Okay. Can he sue to stop the enforcement of the harsher punishment? What does this sound like? Does this even sound like con law? No, what does it sound like? Some civ pro, some. The answers definitely sound like civ pro, right? And then what is the whole concept of like the government making a punishment worse and then they apply it retroactively to people? As ex post facto from crim law, right? So, we got a whole bunch of different doctrines going on here. What do we do with this question, right? So, are there any choices that we can eliminate? There is an answer on here about ex post facto. Have you guys delved into crim yet? Okay. I'm just going to tell you then, when you get to crim and you start studying it in detail, you'll get here. Ex post facto only applies to criminal punishments. Criminal punishments. What is a criminal punishment in our mind? What do we think of? First thing. Jail, right? Getting locked up. And all that comes with that. Is this dude locked up? No. Is anything in this law making him be locked up? No. So we don't have an ex post facto issue. That's out. The trigger, the key word that lets us know that is they tell us it's a civil scheme. They say that right in the fact pattern. So this is bonus crim law coverage right here. Ex post facto only applies to criminal punishment. If you see the word civil, So we can get rid of that one. So now we got a third chance to get it right. Let's look at C. Congress has the power to make substantive changes to federal civil statutes and direct the federal courts to apply those changes. What sounds maybe wrong about this one?
The state's telling the federal what to do?
Yes! So here's one we can kind of get rid of, right? Yeah, Congress can change the law. They change the law all the time. Do they get to tell the courts what to do? No, that's the trigger that one's bad. Separation of powers problem, right? Remember when we talked about congressional powers, being the boss of the courts isn't one of them. So that one's out. So now we got a 50-50 chance. Let's look at A. The new law prescribed greater punishment for the violation than was prescribed at the time the violation was committed. Do we have punishment going on? No. Not really. Mm-hmm. Right? I mean, it might feel like punishment to have to pay a fine and stay out of the parks. But a parking ticket, I hate to tell you, is not punishment. Punishment is jail, it's probation, it's ankle bracelet. It's the stuff on the cop show. And A and D also look a lot the same, right? Those are kind of the same answer. So we can get rid of that. So then we're left with B. This was a final judgment. And think about that. That is a variation of the answer in C, right? The court already decided. The court already did its thing. Congress doesn't get to come in and tell the court after the fact what it should do. So we can, even if we don't know the answer, we can back in through logic to the right choice. Does that help? Okay. Also, this may be one of those ones that we just missed, right? We missed. This is long. This is going to take a lot of our time. We might not get the right answer. It's okay. Which other ones? Yeah.
Number 15. So this one seems really easy when I first read it, but then I thought because it was restricting terminating all of the funding for that particular area, even though I realized it was a very small percentage.
Yes. Yeah. So I actually did the same thing you did, and when I took this, I got that one wrong for the exact reason that you're talking about, because I didn't read the question and I didn't read the answers with enough detail. So I saw Congress is taking away all the funding, and I thought, oh, that's coercive. They can't take all the money away. And I didn't pay attention to the 1%. They can take 1% away. That's not that much at all. A state could come up with 1% in funding easily. So for me, I had a reading comprehension issue. I suspect that probably happened to some of you. Yeah. Obviously, you have to read the questions with sufficient detail to understand what's being asked. That's an obvious one. And I, got really tempted to blow through that one. And I was like, wait, what? Oh, it's not all of the funding. It's just 1%. It's all of the 1%. Did it help to look for that keyword percent? Did that help you trigger in on what type of question this was? Good. The more of these you do, the more practice questions you do, even if you get them wrong, even if all you do is just eyeball the question or the facts, that's going to help you start spotting how these topics are being tested and what the key fact patterns are going to look like. Does that help with that question? Yeah. Yes. 8.
I guess my problem here is because there was only one daycare program, there weren't many, so I think A, because if you're only endorsing one, I would think that would be the establishment of a provision.
So yeah, let's walk through our test, our establishment clause test. Secular legislative purpose, do we have that?
Yes.
Primary impact doesn't advance or inhibit religion. Do we have that? That's okay, right? The program doesn't have anything to do with religion.
Yeah.
So we're getting to a question of excessive entanglement. Do we have that? There we go. There's the answer. So, let me think of the best way to say this. It's important when you look at the question that you correctly identify what issue and then walk mentally through the test, because some of these answers are going to sound good. They're going to sound, if you don't go through step by step the test, some of these answers are going to sound like things that appeal to your sense of logical reasoning and appeal to your heart sometimes. You're going to want a party to win because the facts are so in their favor, but they're not going to win because of some aspect of the test. And if you don't walk step by step through the test mentally, you might inadvertently pick the wrong answer. So just by remembering the test and then walking through the steps, that's how we get to the answer here. Yeah. 16. Okay. All right, This is the one where, okay, state is losing its tax money. It prohibits a cost of living increase for state employee pensions. A state organization of employees sues in federal court to reinstate the increase. Okay, this is one we didn't talk about. We didn't talk about the contract clause, right? We don't know what that is. Uh-oh, what are we going to do? What did I tell you to do if you don't know? Either pick one and move on. Did anybody do that? Yeah. Or, what else? What can we do? Try to use our logic and mark off ones we know are definitely wrong. So let's look at our possible choices. So A tells us that the employees are going to win because of a contract with the state. Okay. B tells us that the employees are going to win if it can show that the state or that the statute violates the state's constitution. Which court are we in? Is there anything we can do with answer B? Do federal courts decide state constitutional claims? Who decides state constitutional claims? Great. There we go. B out. Already we've improved our chances of getting this right. C. The employee suit will be dismissed because the 11th Amendment prohibits a state citizen from suing a state official for official acts in a federal court. Yes, but only as to what kind of damages? Money damages. Are we asking for money damages here? No, we're asking for injunctive relief. Do something, stop doing something, right? There we go, that one's out. How about D? The employees will not prevail because the state always has the power to amend its own legislation. Always? Always is a trigger word in these questions because you guys know from law school there ain't nothing in the law that is always. Right? I mean, okay, that's got to be wrong, right? And yes, of course, a state can change its laws, but not in an unconstitutional way. So there we go. We've gotten rid of the 3 wrong answers. Must be the contract clause. Now, I didn't tell you what the contract clause is because it is a minute area of constitutional law, but there is a provision that prohibits the government from impairing retroactively contracts that it has already executed. Other ones, yeah.
24.
Okay. This is the one where churches get to veto liquor licenses. I mean, right away, what are we thinking here? Just what's your gut on this? Establishment clause, right? Churches. Ding, ding, ding. And also, does this sound right?
No.
Can you think of anything in your experience where the government has given churches the power to say yes or no to something that the government is doing? No, this sounds bad right away, right? Right away, our thinking caps are telling us to look for an answer that invalidates this particular program. Then we get the clerk trying to sit on the city council. And to deal with the situation of messing up and outsourcing liquor licensing to the church, the government is saying, oh, nobody that's religious can be on the city council. What is that sounding like? Free exercise. So we've got both components of the freedom of religion in this question. Yeah.
Why that confused me, though, is because even though the cleric is sitting on the board, he's functioning as a city board member, not as a cleric. So he's not exercising any religious freedoms by being on that board.
True. But what would he have to do in order to comply with the law and be on the board? What does he have to do? Give up his religion.
Oh, okay.
Right? He has to stop doing his religion in order to be able to be on the board. And the government cannot make you stop doing your religion.
Okay, gotcha.
Yeah.
I was just gonna ask you to 22.
Sure. Okay, this is the one where they're putting the cable lines through the apartment building. What does that sound like? Takings clause. What kind of taking? Physical taking. Now remember, the government can physically take your property. They are allowed to do that. But what do they have to give you? Just compensation. Does this program give the apartment building owner any kind of money? No. So this is a taking without just compensation. That's A. If we didn't jump to that answer, how can we get rid of the other ones? So B is the government does not have a right to require owners of private property to allow private installation of cable lines. Is that true? No, that's not true. The government can take your property. How about C? The ordinance is a regulation and not a taking. It is a taking. The government is putting stuff in your property. That is a taking. And then D, any taking here is de minimis. Does that sound tempting? Maybe a little bit. I mean, is it really that big of a deal that a little cable is like going through the walls? Maybe that's not a huge deal. Did I tell you about any de minimis exception to physical taking?
No.
No, there isn't one. The takings clause would still apply if all it was like a piece of paper has to go in your home or whatever. That could still be a taking of your space. Doesn't matter how small the invasion is. Yeah. Yep.
There's one confusion when we discussed, when we were talking about the state and the federal question.
Yes.
That's where I understand.
Yeah, okay. And this is also tricky. So these might be ones that you just don't get right, and it's okay. You're not likely to see more than one question. All right. In this case, a guy was litigating his constitutional rights in state court. And the state court said, yep, you have a state constitutional right, and it looks exactly the same as your federal constitutional right. So what we're going to do is, let's put this in like Kentucky terms. Like what the Kentucky Supreme Court is going to do is we're going to just look at all the U.S. Supreme Court's law on your right instead of our own. We'll just analogize to that because these things are equal. Which right did the state Supreme Court actually resolve, though? A state right or a federal right? State right.
It was a state statute that governed it.
Yes. So when the Supreme Court of a state resolves a state right, even if they only do that by looking at analogous federal law, they're resolving a state question. That's an independent and adequate state basis for the decision. Federal courts don't get involved in that.
So the state statute has the same rules as like for freedom of speech as federal, but you want it to be in state court, even though they're equal, but it's also federal and state. Like it's not a state statute, it's federal and state rules. Then that's when you're kicked out of federal because you resolved it in state. Because the statutes are the same, federal and state. Because here it's not the same. The state rule is different than federal.
Right. Yes. If the rules are different and you've raised both, then you can claim the federal rule or federal court status all day long. The problem arises when you are only raising a state right. So if this guy had said, I have rights under the state law and the federal law, guess what? He's going to the Supreme Court, right? But because the state's court's analysis was only about state law, they only decided a claim of state law, the federal court doesn't intervene. Is that helping? This doctrine is really tricky. And it's kind of case by case. You have to see a fact pattern that triggers it. Yeah.
What if the right he's litigating was incorporated under the 14th Amendment?
It doesn't matter. He would still have to say, I am raising my federal rights and my state rights. He didn't do that. He just raised his state rights. Even if those state rights are coextensive with federal rights, they're still an apple, they're not an orange. Right? Does that make sense? Maybe that's looking at it that way, apples and oranges.
So if this one was not resolving the state issue that they were looking at, or like the state and the federal are the same, and it resolved, then I guess I'm trying to figure out what the opposite of this would be. Like if they actually resolved the federal issue.
The opposite, so it starts with the claim itself. Look more, if you see a question that has the words independent and adequate state grounds in it, look more at what the person is claiming than what the court necessarily did.
So the claim is the trick.
Yeah. Other ones. Yeah, go ahead.
21.
21. All right. City passed an ordinance prohibiting its police officers from moonlighting with doing a second job. They wanted to make sure that firefighters were going to be available in case of an emergency. That sounds legit, right? But only the firefighters had this restriction. Everybody else that worked for the city could moonlight and get extra money. A police officer wants to work at a strip club to get extra money after hours. Is this constitutional? So what do we have possibly going on here? First of all, who's regulating? Which kind of government? A city. So we're not going to worry about contract clause and tax and spend and all that Congress stuff. What do we know about individual rights with respect to state government? What rights could be triggered here? Got a strip club in here. What could that be? Could be the First Amendment. What else do we have going on?
Classifying police and firefighters versus other citizens.
Different groups, right? So there's emergency personnel, and then there's everybody else that works for the city. So we've got the government making two different groups. What is that? What right do we start thinking of when we start thinking about treating different groups differently? Equal protection. Now our mind might start going to privileges and immunities, right? Because that also deals with states treating different kinds of people differently, but that has to do with citizenship and where they live. And in this fact pattern, it seems like everybody's all within the city. So we're not going to go to privileges and immunities, although maybe our brain might go there. This is equal protection. We've got two different groups that are being treated differently. What kind of classes do we have? Do we have race, alienage, gender? No, we don't have any kind of protected class here. So what is our test? Rational basis. What are we looking for? Legitimate government interest? Rationally related to that interest, right? Do we see those words in the answers? Yeah, so that one, it's really just about, and this is what I said at the beginning, identifying the test, memorizing the words, finding the words, right? Other questions? Is there anything about con law that is continuing to confuse you? Okay, one last tip. Pizza should be here shortly. I know you guys are probably hungry. Aha! The food is here. Perfect timing. Con law is historically an area where people nationwide do poorly. So this is a place, if you can master it, where you can make up points. The questions in reality are not that hard, and it's really about memorizing the test and spotting the issue, and I think the more practice you do, you're going to start to see common fact patterns. The same sorts of things going on in terms of how they're testing these topics. So it's really easy, if you put the time in, to get a lot of these right. Okay? I am around this summer if you have questions about con law or anything else. We want to be helpful to you, so reach out at any time. And good luck with your studies. Thank you.